Welcome, everyone, to this employment law session. Thank you so much for joining me. I'm Lior Samfiru, the employment lawyer, and I am here, as I am every week, to help you, to answer your questions, to tell you what you need to know about employment law and workplace rights. Again, I'm Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. My firm, you can easily find us in Ontario, in BC, and in Alberta. So we've got your back if you're in one of those provinces. We can help you with employment law. We can tell you what you need to know. But right now, this is a live session here for you to find out about your rights, to ask me questions about those workplace issues. Maybe today hasn't been a great day. Maybe your boss did something today or yesterday. You're not sure if they're allowed to do that. Well, let's ask the question. Ask it right now. I'll tell you. And maybe we can make the rest of your day a bit better when you have the knowledge, when you have the information. Remember, I've said this before. Our employment laws are here for you, for employees. They're here to help you. We have all kinds of employment laws from different sources. They're here to help you. Too many people don't understand what those laws are. They don't appreciate just how much laws we have and how the law can help you. Well, if you're watching right now, you don't have to be one of those people. You can actually know your rights, know what to do, know what the law does, and how to deal with the situation if you've been wrongfully dismissed, if you've been constructively dismissed, if you've been harassed, if your human rights have been violated. You get the idea. If your job has been affected, if your workplace rights have been impacted, ask the question right now. Last time I was here, had lots of questions, lots of calls, barely got through them. I want even more questions today. Challenge me. I want to answer all of them. I see some questions that have just come in. I'm going to start answering them in a second. Before I do, let me give you some other contact information. If you want to connect with me and my team off social media to have a private chat or a private email exchange, man, it's so easy to do. You just go to employmentlawyer.ca. See that address on the screen right now? Employmentlawyer.ca. You can get the phone number there. You can get the email address there. You can fill out a form if you want, and then my team will just call you directly. It's so easy to connect. But right now I'm live. Again, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm here to answer your questions. Questions are coming in. It's going to be one of those great days where I get lots of questions. Makes me happy. I'm just that kind of guy. So make sure that you get your question answered as well. I say let's get through it right now. In the meantime, as you're listening to me, ask your question. Wrongful dismissal, constructive dismissal, severance package, human rights, changes to your job, temporary layoffs. You get the idea. Ask the question. All right, let's start today. First question from Yusuf today. What is the minimum settlement a person can accept from an employer in cases of termination due to discrimination or disability? What factors should be considered in determining this? Well, so Yusuf, the settlement could be $1,000. It could be $5 million, right? Depends on your situation. Depends on what this discrimination was, how much you were earning, what kind of a job you had, how long you've worked. Here's the thing. You need anyone in that situation. If you're let go, if you've been discriminated against, we need to go through that analysis with you, okay? It's not a one size fits all. We need to go through that analysis with you. To do that, it's very easy to do. You call us. And to connect with me and my team, very easy. Just go to employmentlawyer.ca. So again, without knowing what your job was, how much you were earning, what happened, I can't say if you're owed $1,000 or several $1,000,000. I just can't say. But what I can tell you is that we can absolutely help you and we can assess your matter very quickly. And the other good news is, Yusuf, usually these matters are not difficult to resolve. So yet another reason to reach my team and myself through employmentlawyer.ca. Be happy to help you. You have all kinds of rights. So let us do what we do and help you. So thank you for that, Yusuf. Any follow-up questions, by the way, Yusuf, I'm still here. Don't be hesitating to ask right now. If you've just joined us, thank you for joining us. Welcome. I'm Lior Samfiru, the employment lawyer, live here on your employment law Q&A session. I'm going to continue answering questions that have come in. Ask yours, please. You got time, lots of time. So ask your question right now. Next question comes to us from LinkedIn from Mukhtar. What about harassment in the workplace? How can you deal with a toxic work environment? So let's start with the idea, Mukhtar, that harassment in the workplace, not acceptable, okay? an employer has to create a workplace that's free of harassment, that's free of bullying, etc. Not appropriate. You want to work in a healthy work environment, not a poison work environment. So what happens if you're dealing with harassment in the workplace? Well, you have to tell your employer and give your employer the opportunity to fix it. So you have to let your employer know in writing, always in writing. Employer, here's what's happening. Here's who's mistreating me or harassing me. Please do something about it. Once you do that, your employer is under a legal obligation to take it seriously, to investigate, and to fix the problem. They have to. It's not that they should do it, they must do it. So if they do that, they do a good job, fantastic. If they don't do a good job, they don't care, we don't investigate, they don't resolve it, you call me. And I can either force them to do it or get you out of there with compensation. So if you've tried to deal with your employer and they haven't done something about it, or maybe you can't deal with your employer, maybe it's the owner of the company that's harassing you, well, who are you going to complain to, right? So if you cannot deal with it internally, you deal with it externally through me. Let me deal with it. Now, the other thing I want to say is this. Remember, if you're being harassed, the person that's harassing you is not going to admit it, right? They're going to deny it. So it's always helpful if you have a way to prove the harassment. So what do I mean? Is there something in writing? Is there a recording? You can record a conversation with someone. Did you write it down when it happened? Is there a way to prove it? If you have a way to prove it, a witness, for example, any of that, if you have a way to prove it, it makes life that much easier. So when you go to your employer, you say, here's the proof. And because if you simply say, this guy's harassing me, that guy's going to say, no, I've never done that. So you want to have some proof. But again, if you can't deal with it internally, contact me again, employmentlawyer.ca to do that. All right, Mukhtar, hopefully that helps and clarifies the thing. Any follow-up questions, feel free to ask them. Oh gosh, love it. Questions have come in. I love it. Makes me happy. So I'm going to continue answering them. If you've just joined us, I'm Lior Samfiru, the employment lawyer, here live, answering questions about employment law, workplace rights, wrongful dismissal, severance. You get it. So ask your question. All right, let's see. Next question from Sagar World Boss. Sagar World Boss. I was laid off since April the 5th. They called me back 3 weeks ago, and then they laid me off again yesterday. Any tips? So you may be able to consider this a termination of employment. Okay, you may be able to say, by doing this, by putting me on this layoff, I don't have to accept it. I don't have to sit at home and wait. I can now treat this as a termination and force you, employer, to pay me severance. So there's really only two options. You sit at home and see what happens, or you treat this as a termination and force them to pay you your full severance. Now, that severance can be many months' pay that they have to pay you. Now, the fact that you've accepted that first layoff doesn't make me happy. It may make things a bit more difficult, but I still want you to reach out to us. But really, those are the only options. You sit at home and accept it. And by the way, if you accept the second layoff, you've now given them the right to do it again and again forever. Okay, bad idea. You may be wanting to simply say now, no, I was going to let that first one slide, but now that you've done it a second time, forget it. That's a termination. Pay me my severance. If that's what you want to do, call me. Okay, don't do anything before we speak. And you can connect with me through employmentlawyer.ca. That's an important reminder that for most people, your employer does not have a right to put you on a temporary layoff. If they do, you would then have the right to consider that a termination and force them to pay you severance. Even though your employer is telling you, we're not letting you go, we're just putting you off work for a few months, we're going to call you back. Doesn't matter. You, the employee, may have the right to say, no, I'm not waiting. I'm considering this a termination. Call this constructive dismissal. Now you have to pay me my full severance. So keep in mind, but before you do anything, as always, you contact me. Great question. Thank you for that. Something that comes up very often. All right, let's see. Continuing to answer questions. Love the questions. Next question on YouTube from Fight for Your Freedom. Should always fight for your freedom. For a professional with 35 years of service, all at the same company with good reviews throughout, does the old Ontario precedent-based guideline of 24 months of severance apply? If so, does it change if the company's operations are based in the US? So first of all, where the company operates is irrelevant. If you work, let's say, in Ontario physically, then it's the laws of Ontario that apply to you. If you work in BC, it's the laws of BC that apply to you. But if the company is headquartered in the US, does not matter. It doesn't change anything. It's where you physically work, not where the company is based out of. Now, for most people, the maximum amount of severance that you can get is 24 months. There are cases where the courts can award and will award more than 24 months, usually with very long employment with senior executives, or where it's going to be unbelievably difficult to find another position. They could go beyond 24 months, 26, 28, etc. But for most people, the maximum is 24 months. And if you've been there for 35 years, even without knowing what kind of a job you were doing or your age, yeah, you're probably going to be owed the maximum, right? Which is 24 months. 35 years is a long, long period of time. So if you lost your job, call me right away. It should not be less than 24 months. So let's get you that so that you can hopefully move on to something else. So thank you for that fight for your freedom. To connect with me, I've said contact me. Easy to do. I'll remind you again how to do that. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. You click some buttons. You'll get the phone number there from me and my team. Email address, all there. Fax number, if you prefer fax number. I think you get it. It's all right there for you. By the way, guys, I'm still here live. So more of questions have come in. I'm going to answer them right now, but I want your question. I don't want you to just read and listen. That's great, but I want you to do more than that. I want you to ask me your question. I know you have questions. That's why you're here, right? So if you have a question about law, employment law, workplace rights, your job, your boss, your compensation, ask it right now, and I'll give you the answer. All right, let's see where we left off. Next one is from STBean2. How difficult is it to deal with a US-based employer when working in Canada? Well, I'm not going to paint all employers with the same brush. Some employers are very easy to deal with. Some are unbelievably difficult to deal with. And by the way, same thing applies with Canadian-based employers. So it's not difficult. It shouldn't be difficult based on where they're based from. What you need to understand is if you work in Canada, the laws of where you work apply to you. So whatever laws they have in the US does not matter. It doesn't have anything at all to do with you. So I deal with US companies all the time. The good news is when I deal with them, they hire lawyers in Canada. The lawyers know exactly what the laws are, so it's very easy to resolve matters. So generally speaking, I don't find it more difficult to deal with US companies. Certain companies are difficult, but that's just the nature of the beast. So don't be afraid of that. Always stand up for your rights. If you have a question or an issue with what the company is doing, if you're not sure if they're complying with Canadian law, no problem. You know what to do. You reach out to me through employmentlawyer.ca, and I'll tell you. It's just that simple. So, no, I don't think you should be concerned about that. We deal with it all the time. All right, let's see more questions. By the way, guys, you still have time. We still have plenty of time to ask your question. If you ask it now, I guarantee you you're getting an answer before I'm done today, okay? So that's, or your money back, by the way. If you don't get your question answered, your money is back. So ask your question right now. Let's make sure that when you turn off your screen, your computer, you know more than you did. You feel better about your legal rights. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm live. So I'm going to continue answering questions. Next question on Facebook from Bridget M. My employer said that we don't get paid for any overtime if it is less than 30 minutes. My employment contract doesn't say anything about this. Is my employer allowed not to pay me for my time if I'm not working a full 30 minutes of overtime? Absolutely not. The question is not how much you work. The question is, did you work beyond the threshold? And here's what I mean. In Ontario, let's use Ontario, for example. In Ontario, the threshold is 44 hours a week. So anything over 44 hours, you get time and a half. All right. Doesn't matter if you work 5 minutes over or 30 minutes or 5 hours over. It's anything over 44 hours, you get overtime at time and a half. Now, if you work less than 44, generally speaking, you don't have to get overtime. Obviously, you have to get paid if you're an hourly employee. You have to get paid for your time, but that's it. So let's say you're a salaried employee. You get a salary. How do you calculate your overtime? Very easy. Whatever your salary is in a week, we divide that by 44. That gives us an hourly rate. And 1.5 times that is your overtime rate. So yes, there's no 30-minute threshold. If you work beyond the overtime amount, you have to get paid. Full stop, always. All right, let's see. Great question. I appreciate that. Next question. Parker has a comment. Parker says, this company is the real deal. They're good. Well, I appreciate that, Parker. Thank you so much. That's very kind of you. By the way, just like everyone else, ask your question with me, Lior Samfiru, the employment lawyer. Let me continue answering them. Ron 20 has our next question. Ron 20. Is there a difference between severance pay and termination pay? I hear both being used, but not sure if they mean different things. Don't worry about it whatsoever. The term usually used is severance. That simply refers to the amount of compensation that you're owed if you lost your job. That's all you need to know. Now, severance pay may be comprised of termination pay and severance pay. It doesn't matter. It can be confusing, and there's no difference. You don't need to even understand that. Usually when you hear the term severance, we're talking about the compensation that you're owed if you lost your job. And that could be 2 months pay, that could be 24 months pay. That's all that matters. So don't worry about the definitions. They don't change anything. They don't give you additional entitlements. You're concerned with what am I owed if I lost my job. So now that I've said that, how much are you owed if you lost your job? Let me tell Ron and everyone else how you can find out what is it that you're owed if you lost your job. Maybe you've lost your job, or maybe you're curious, or maybe you're just interested to know, hey, what would happen if I lost my job? Well, here's what you do. You go to pocketemploymentlawyer.ca. See that address on the screen, pocketemploymentlawyer.ca, and you use the severance calculator. It's as simple as that. You click on the severance calculator. First thing you'll see when you go to pocketemploymentlawyer.ca. Once you're there, you answer a few questions, and it's going to tell you how many months of severance you are owed. It can even calculate that in dollars if you wanted to. It's unbelievably simple to use, unbelievably fast, and completely free and completely anonymous. You don't put in a credit card number. You don't even put in your name. You don't even put in the company's name. It's simply there for you to help you understand and assess how much you are owed. Well over 2 million people across Canada have used it. You can use it too. Why wouldn't you? Maybe you're staring at a severance letter and you just want to understand, is this good? Is it not good? Maybe you think tomorrow you're going to have a meeting with your boss. They're going to let you go. You want to be prepared. You want to understand how much you're actually owed. Go to pocketemploymentlawyer.ca, use the severance calculator, find out the dollar amount or the number of months of pay that you're owed. Check it out. All right. Thank you for that. Continue. Next question. Let's see. By the way, before I take the next question, ask, guys, we still have at least 10, 12 minutes or so. Plenty of time for a bunch of questions more to be answered. I'm still here live, Lior Samfiru, the employment lawyer, and I'm only here for one reason, because I want questions to answer. I want to have the opportunity to have this discussion with you, tell you what you need to know. So if you're just joining us, welcome. Ask your question about employment law. Breakout Joe has our next question. Suffered a heart attack 4 years ago and moved into an admin position. I was working in construction. My employer is now trying to push me into more physical work despite my limitation. What can I do? So the first thing you do, Joe, is you get a note from your doctor, okay, telling your employer what your limitations are. Make sure that it's not you saying, oh, I have this limitation or that limitation. That's not good enough, right? It has to be from your doctor. Now, once your doctor provides that note, if they still won't follow those limitations, well, that could be a human rights violation. That could be a constructive dismissal. At that point, you call me. By the way, once they hear from me, you'll see how quickly, all of a sudden, no problem. Of course, we'll accommodate. This was all just a big misunderstanding, right? Once they hear from me, that's what happens. So if your doctor provides a note, they have to follow that note. If they have the ability to accommodate you, then they must accommodate you. It's as simple as that. If they don't, you call me right away. Again, to connect with me, it's employmentlawyer.ca. But get that doctor's note. Most people, I would think, don't understand or appreciate just how powerful that doctor's note is. You need that doctor's note to say, these are the limitations. You can't lift more than 50 pounds, or you can't stand more than 2 hours. Whatever those limitations are, have your doctor provide that. they have to then accommodate you. And if they don't, you know what to do. You connect with me through employmentlawyer.ca. All right, let's see. Continuing to answer questions. Callie has our next question from YouTube. 6 months ago, I accepted a position change that included a pay increase. The contract stated that the position was only for 6 months and may be extended at the end. But if not, I would return to my normal position. I'm going to return to my old job, but is my employer allowed to reduce my wage as well? So if the deal was that after 6 months you may be brought back to your old position, that means that the old position comes with the old pay. So your employer is able to say, now you're going to go back to your old job that you agreed to take, and that job only pays this much, so that's how much we're going to pay you. So yes, they can reduce your pay back to the level of that old position. They don't have to maintain the higher pay if you're no longer doing that new job. Now, if they simply had promoted you, but never said that you could go back to the old job, they wouldn't have the ability to do this. But if what you signed says that after 6 months they can take you back to that old job, now they have the right to take you to that old job and reduce your pay to pay you what that old job pays. Hopefully that makes sense. If you have any follow-up questions, I'm still here. Happy to answer that and happy to provide more information. Let's see. Breakout Joe has a follow-up question. Does making a human rights complaint against an employer make other employers leery of hiring you in the future? Well, how would they know about that? They wouldn't know about it. There's no database of human rights complaints that you filed. The only time there's potentially, not even always, potentially a record is if it actually goes to a hearing and there's a decision by the tribunal. The 99.9% of these matters resolved before there's ever any hearing. So no, you don't have to worry about it. You file a complaint, those get resolved. No one ever knows about it. There's no database. You can Google that. So there's nothing to worry about. And oftentimes people are afraid of the legal process. They decide not to pursue their entitlements because they're afraid of the process. They think it's going to be long. They think it's going to be expensive. They think it's going to be held against them somehow. Don't worry about that. When it comes to employment law and pursuing your employment rights, for the most part, it's a straightforward process. It's fairly quick. And in most cases, it's inexpensive. Most of our cases, for example, that we take on are on a contingency basis. We understand that not everyone can afford to pay us by the hour, right? So we do it on contingency basis where we only take a percentage of anything that we get. And either way, we negotiate compensation for legal fees from the other side on top of other amounts. So don't be afraid of the process. Don't be afraid of the expense. Let's have that chat at least so you can understand all the information before you make that decision. Again, to connect with me and my team, very, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Let's see. Breakout Joe says, thank you. Great information. I appreciate your time. Wish I knew this all years ago. Well, better late than never. Now you know. And by the way, now that you know, Joe, you want to spread the word, right? You want to tell others that you have rights. There's things that you can do, and there's somewhere you can go to if you have a workplace issue. So thank you for that. All right, next question from Yasin. I just got a termination letter without cause from my current employer. I have worked there since 2019. They offered me 2 weeks of termination pay and 3 weeks gratuity pay, so a total of 5 weeks. Should I sign the termination letter and accept their final payment? No. Now, yes, and I don't know. I know you've been there since 2019, but I don't know your age and I don't know the job that you were doing. But what I can tell you is you're likely owed north of 6 months pay. Okay, months, not weeks. You've been offered 5 weeks. You're probably owed 6 months. You do the math. Obviously, that's not something you can accept ever. Why would you accept 5 weeks when you're owed 6 months? So no, you cannot, should not, under any circumstances, accept that. What do you do instead? Just call us, okay? Let us do what we do. Let us go to the company and negotiate the proper severance because they're simply hoping that you're not going to know better. They're hoping that you will think, oh, 5 weeks is okay, so I sign this. That's the hope. Well, you know better because you just heard me say that. So they're not going to get away with it. Let's make sure you get everything that you're owed. By the way, this situation from Yasin, extremely common. 90% of termination offers, severance offers, are not adequate. They're less than what the person is owed. So chances are, if you're looking at a severance offer, that you're one of those 90%, that you're owed much, much more. That's why you go to the severance calculator. By the way, you can find that at pocketemploymentlawyer.ca. See that on the screen. Or just call me, okay? Easy to do. So do the smart thing, the right thing if you lost your job. All right. We have time maybe for a couple more questions. Let's see how we're doing with that. Okay, next question from MS Run. I have been working as an independent contractor for the last 10 years. I'm full-time, but do all of my own taxes each year. I got a new job offer, and my employer got very upset because I gave 4 weeks notice when their regular employees are required to give 8. Now the employer is saying they have enough evidence to prove that I am a traditional employee and will take me to court if I don't give them 8 weeks. Can they do this? What can I do? Wow. I don't say this often, but this is a dumb employer. Here's why. Yeah, you're probably an employee, but the fact that you're an employee doesn't mean you have to give them 8 weeks. Not at all. That's nonsense. The only time you have to give them 8 weeks is if you sign a contract that says that. You being an employee doesn't matter. But here's what it does happen. If they prove that you're an employee, they're going to have to pay you vacation pay, and they're going to have to pay you holiday pay, and they're going to have to pay you outstanding overtime pay if you work that. So all these things, they have to pay you, and you still won't have to give them 8 weeks notice. So that's what I'm saying. That's a dumb employer. By the way, this is a situation where it's very common when someone has been misclassified. If you worked full-time for a company for 10 years, I don't care what they say. You are an employee. You look like an employee. You act like an employee. Well, guess what? You're an employee. Does not matter what you sign, how you pay your taxes. None of that matters. Okay? Look like an employee and act like an employee. You are an employee. So you can simply tell them, I'm not giving you 8 weeks. If they want to prove that you're an employee and pay you a bunch of money that they owe you, hey, let them. That's fantastic. So hopefully that makes sense, MS Run, and you get the answers that you need there. All right, I'll take one last question. We have time. Just came in from A. Brown. Let's see. What sort of rights do contractors have? Long-time contract position, but looks like I'm not getting renewed. So you are probably an employee. If you work for a company for a long time, you are an employee. You've been misclassified. So if now they say, okay, we're not going to bring you back, that's a termination, meaning you're owed severance. So you're asking me what rights? You have the right to get severance. Now, I don't know how long you've worked there, and I don't know what kind of a job or what you were earning. So I'm not able to tell you right now how much severance you're owed, other than to say you're owed severance. You've been likely misclassified. So what I want you to do is I want you to connect with me ASAP, as soon as possible, okay? You could do that through employmentlawyer.ca. Again, employmentlawyer.ca. And I'll help you get that severance that you're owed. It's as simple as that. By the way, for all of you at home, as we wrap up this session, just because I'm turning off the camera here doesn't mean I'm going anywhere. My team and I are available. You can find us at employmentlawyer.ca. Tomorrow, right here, by the way, one of my colleagues is going to be back here to talk about employment law. Same time, same place. You can join us here if you haven't got your question answered, so you can get more questions live here at 1 p.m. Eastern tomorrow. I'll be back next week, but please don't wait until then. If you have follow-up question, if you didn't get your question answered today, easy to do. Go to employmentlawyer.ca. You can ask the question there, or you can contact me by phone or email. It's all there for you right there. Guys, lots of questions today. I really, really appreciate you asking and giving me the opportunity to help you. Thank you always so much for attending. Look forward to connecting with you again. You stay healthy, stay well, and we'll be in touch. Thank you. I'm Lior Samfiru, the Employment Lawyer. Bye now.